Benjamin. Good evening, ladies and gentlemen. Welcome to you all. Super excited to be here. My name is Latoya Benjamin. I serve as the director to the Du Bois Fund Center for Public Policy. Ladies and gentlemen, a brief background about ourselves. We are an Academy of Scholar Activists and advocates dedicated to forging solutions to the challenges confronting people of color living within urban communities in the United States and throughout the urban community and African diaspora. DBC produces research, formulates policies, sponsors conferences, and produces public affairs media programming such as this that advances economic and social justice. This evening, we're talking all things estate planning 101. We have a phenomenal subject matter expert here to share with you all, Ms. Rhonda Maco. Ms. Maco has been an esteemed member of the New York State Bar practicing law for over 20 years. She is a fierce advocate for justice and she works hard advocating for clients as well as her community. In 2009, she founded the law office of Rhonda Maco, located in Garden City, and is an esteemed adjunct here with the Du Bois Fund Center. Ladies and gentlemen, please help us welcome Ms. Rhonda Maco.
Thank you so much for that introduction. And thank you all for being here this evening for Estate Planning 101. So just so we want to make sure that people understand what is involved in estate planning. And our goal tonight is to just get people into the mindset of understanding what's involved and to take proactive steps to start estate planning. And so you're going to be familiar with some terms. You're going to be familiar with how estate planning works. And then it will really just get your memory going as to what your assets are, who is important in your life, what issues you may be having, so that way you can start your planning now. Planning needs to happen now. This is not something that happens when you're in your 60s, 70s, or even your 50s. This is something that should happen anytime. So estate planning is for everyone. And depending upon what your circumstances are, it's important to understand what's available to you and what you can start doing now to make sure that you're going to protect your assets and also you create that generational wealth that people are often talking about but don't really understand how to do that. So we're going to touch upon those things tonight, and then we're going to continue with other series that will specifically address certain aspects of estate planning. So let's get started. Let me just look in the chat real quick. So if you guys can just put where you're calling from, so that way I can just see where you're tuning in from, and I'll ask some questions later on during this presentation. So let me share my screen, and I just want to make sure that you can see my screen once I do that. So, can you see that?
Yes.
Okay, great. All right. So if you could see that, let's start from the beginning. And again, this is the essentials of estate planning. We're not going to go in depth on every issue of estate planning because that would take us forever. And we're going to have subsequent webinars so that way you can get more information. We're also going to, you are going to have the ability to sign up for one-on-one consultation with me, but we will talk about that at the end of the presentation. So, with that, let's begin. So we're going to talk about the essentials of estate planning. What are we really talking about? We're talking about protecting your assets, forging a lasting legacy, and creating generational wealth. So, how do we do that? So, where do we begin? Um, It all really starts with your mindset. You really have to understand that things need to happen, right? We need to make sure that we're doing things in our lives to make sure that we are planning properly. So, what do I mean when I say your mindset? Let's first talk about things that we do in our daily lives, our spending habits, right? I mean, a lot of times when people think about, what they're doing and what their goals are, we don't really think about how our spending habits affect what's going to happen in the future, our future, and for the future of those we love, right? So, how are those spending habits and what can we do to curtail or tweak or address certain issues that we may be having with those type of spending habits. Think about all of the relationships in your life, good and bad, and start to analyze those relationships. So, for those of you who come from medium-sized family, big family, some of us are only children, but we have other people that we want to help and take care of. In different stages of our lives, we may have different people that we have to think about. So I'll give you the perfect example. So before I got married and had my own kids, first of all, I come from a family of eight. I'm number five of eight children. And my brothers and sisters, most of them already had children before I had kids. So I was thinking about estate planning very early on in my life, especially after I finished law school. And I didn't have kids at the time, but I had nieces and nephews. And for me, what was important at the time is I'm a first generation college graduate, actually. So again, I was number five. I'm number five of eight children. And since I was the first one to go to college and the first to graduate, I was thinking about my nieces and nephews. We didn't grow up with money, we didn't come from money or anything like that. And I wanted to make sure that they had the opportunity to go to college the way I did. So, what I did when I was younger, I got an insurance policy and made them beneficiaries. And as time went on, I always check on these insurance policies as I had more nieces and nephews added on to that because going to college was something that was very important to me. So then my life changed. Now I'm married, have kids. Then I did other things. But initially, my beneficiaries were my nieces and nephews because I had specific goals for what I wanted them to do. So it's that type of analyzation when you're talking about, who's in your life, what are the goals. You have to talk to people, or you have to really understand. Who if you have good relationships with your family members, whether it's your siblings, your parents, your nieces and nephews, or whoever, you know, have some in-depth conversations with them. What are their goals? Do you want to help them with anything? So these are all the different things that you need to think about. So when I say think about all the relationships in your life, if you're married or if you have a partner or you have kids, sit down and figure out who's where, what you want to provide for them. Think about what their goals and okay, I can help them meet that. So it is a process depending upon how many people we're talking about in your life. Again, for me, since I come from a big family, I have a big family and it has grown and things of that nature, and I want to be able to provide. That may not be your goal, but you need to start thinking about those relationships now so that way you can plan how to provide or how to be able to help someone or to make sure your assets go to whomever you want them to go to. So it's that type of thinking that is really involved when you're talking about estate planning. So what are you working towards right now in your life? Because this is where you have to start. Wherever you are right now, that's where we are. And that we have to be honest about where we are and the things that we need to do. So right now, listen, you might be in a phase in your life where you're just paying the bills. There's nothing to be ashamed of. We all have been there. I know I've been there. I know when I first bought my house, we were just trying to pay the mortgage on time. That was it. And then as time goes by, you get increases or whatever, you get a job, you maybe you're an entrepreneur, you're making money, you do all these things. Then say, okay, what can I do? So every year we would figure out, okay, how much more disposable income do we have? Okay, so what could we do with this money? What could we, we're paying bills. One of my goals was to get on auto pay with all of my bills. That's what I wanted to do. And then the next goal I had was I wanted to have a better credit score than my husband. I had that type of competitiveness. And we talked about these things. And these are like fun, good goals to really work towards in your life when you really think about it. This is all a part of planning. It really is. So, where are you in your life? Are you just still paying bills? And how can you move or shift from just paying bills to now savings, creating wealth? Do you need a financial planner? What options are available? You got to shift your mindset at some point. There's no shame in where you start. We all start somewhere, but then we have to get on a path where we're thinking about the bigger picture, thinking about other things that we want to do. Just like budgeting. People should have, like, if you have a business, you should have a budget, right? But we should all have budgets in our personal lives too. What monthly expenses? Where can we save here? These banks now have tools where they'll help you save. When you get paid, they can put aside there's features where automatically a certain amount could go somewhere, go into some account. There's a lot of different things that you can do to get on that track so that way you can start building and not just paying bills. We're talking about obligations versus opportunities, right? So that's what we want to get into that mindset. And we could start that right now and think about that. And then once you make that assessment of what you need to do in order to go from A to B to C to D, what necessary adjustments that do you need to make, including the acknowledgement that change must take place. So again, is nothing to be ashamed about. If you're an impulse buyer and you see all the different things that you're buying all the time, if Amazon packages are coming to your house every day, and you're saying that you can't do X, Y, and Z, then, maybe it's something you need to look at. But once you acknowledge that something needs to be changed, then you actually have to change it. So again, this is the level of detail or involvement that you should be considering when you're thinking about estate planning. There's the acknowledgement, there's the identification of the specific issues that you need to address. And sometimes that those issues are, may create some tension, especially if you have a partner. Sometimes you need to sit down and have a discussion about what those issues are. But if there's going to be change, you have to be willing to confront those issues and say, listen, this is what we're dealing with and this is what we have to do. I always tell people, like, when you're in relationships, you just, all types of relationships have whatever flow they have, right? But if you have two people who are bad spenders, you're in trouble. If you have two people who know how to save and you're good at, curtailing spending and stuff like that, that's great. Usually relationships have, it's one person who's good at saving and another person who's not the best at saving. You could survive with that. That means you need to do a little talking about what's going on and how we can work together. But if you have two people who don't know how to save and constantly spending and not looking at what's going on, that's a recipe for disaster. So, again, you have to be willing to acknowledge what's going on and be also willing to make the necessary changes in order for you to move and progress into that next stage. And then again, you create that action plan. And then after that, it's execution and implementation. You have to check in every month, talk about what's going on, and make the necessary adjustments. But at the end of the day, what are we talking about here? After all the acknowledgement, all the writing down, oh, this is what we have to do and why we have to do it and what we're trying to accomplish, you must take action. That's it. It has to happen. And if you're not willing to take the action, then this is all just time that you're wasting and anything can happen. And that's just how life is. And that's not to make anyone paranoid, but it's to try to plan as much as you possibly can. Now, does every plan work out? Of course not. Some things you just can't plan for. Nothing's going to be perfect, but there'll be tweaks and things that you have to make. But we try to put ourselves in the best position we possibly can. We educate ourselves. When you go to seminars like this and you get information and you write it down and then you have questions, seek out advice from the appropriate people so that way you can have those questions answered. Now, there's something I really do want to talk about, and I talk about this a lot of times when I'm in person with people. But you know that phrase that people always say, um, health is wealth? Well, that phrase is probably one of the best phrases that I talk about all the time. And I think people use it now, not necessarily as a punchline, but they use it and not really understanding what that means. So now, and when you talk about health is wealth, a lot of people don't understand that when you're talking about estate planning, if it's your estate that you're talking about, it would behoove you to make sure that you are healthy. Getting a healthy lifestyle and start to take control of your health is really important. And the reason why is, a lot of people don't understand that one of the easiest ways that you can create wealth for your children or your loved ones that you are trying to provide for is through insurance. Now, we're going to talk about, we have a whole seminar where we're going to talk about all types of insurance and make people understand, what insurance does, what it can do, purposes, and all that kind of stuff. But right now, I just want you to understand that this is an issue that a lot of us overlook, the value of insurance. Usually, when we think about insurance, we get the required insurance. We all have to have insurance on our cars. Whenever I talk to people about life insurance, immediately people always, I can't afford that. But again, when you start to look at the things that you spend money on, that Starbucks cup of coffee, that's what, $7, and you get that not even every day. If you get it 3 times a day, 3 times a week, I'm sorry. 3 times a week, that's still, 21, $25, whatever, a week. And 9 times out of 10, you're probably getting it more than that if that's what you're drinking. But there's other things that we do, whether we eat out, whether we get lunch, when we're in the office and stuff like that. If you start to tally up those things and you see what you're spending weekly, you probably see that the things that you say you can't afford, which are estate planning tools, you probably can afford. And here's the thing about insurance. Getting a life insurance policy, whether it's whole life, and that's the one that people say they can't really afford a lot of times, or term insurance, that is one of the quickest ways or, easiest ways to provide something for your children or people you love if you are no longer here. Now, a lot of times people always get burial insurance. That does not provide generational wealth. And I say that because a lot of times we're only in a position to get the bare minimum. I see the commercials on TV where they'll say, you can get this policy, the rates will never go up, blah, 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 and the amount is like 10,000, 20,000. That's fine if that's all you can do. But my point is when you are healthy and you are taking care of yourself, if there are illnesses that need to be addressed and you take control of your health as much as you possibly can, you would be able to qualify for these types of insurance that you would be able to get for whomever you might need. And again, we'll talk more about that. My point is that insurance companies are allowed to discriminate. They are allowed to do that. And so when we're not healthy, they will deny you, for any type of insurance that you might need, except for those that are required, like insurance for your car. Sometimes they'll even deny you insurance for your house. We'll talk about stuff like that at another time. But when you're talking about insurance for life insurance and the things that you can do with that type of insurance, whole life insurance where it actually builds up a cash value. If your kids are trying to go to college, you get that policy before they're born. By the time they got to go to college, you'll be able to do certain things to help them with that. Or there's plenty of things. And again, we'll talk more about that. But that all starts with you being healthy, right? Because if you're not healthy, they'll find anything. They'll make you take some type of exam, something will come up, high blood pressure, diabetes, something like that. Next thing you know, you're denied. So we have to, in addition to starting with the mindset and changing things that we're doing in our lives, part of that means we have to take control of our health and start to do things so that way we can be in a better position to provide for our children while we're trying to build our own wealth. And again, I'll use that example of my life. That's what I did when I was younger is I thought insurance was very important and I put those policies in place. Some of them I did before I was married. So now next month I'll be married 20 years. And these insurance policies will be able to work for me should I need them. Doesn't mean I need to use them, but I can use them if I need to. But that's the type of planning we're talking about. So when we say health is wealth, that's what we mean. In a lot of other ways too, but you have to think about all the things that you could take advantage of when you are healthy that you cannot do when you're not healthy. 9 times out of 10, when people come to my office with issues that they need to address with respect to estate planning, that's because somebody's now ill. And, you know, things happen, they do happen. But a lot of times people say, I meant to call you years ago, or I remember you did something and I didn't call you. And now we're in a situation where the opportunities are not as plentiful. And now there's an emergency. And now we have to do something, but we can't do everything to protect all of your assets because now we have to deal with this medical emergency. So, we really need to think about what we're doing on every aspect of our lives so that way we can really get the benefits of all those different opportunities and products and things that are out there. And it starts with us, it starts with you. So I just wanted to say that. So now what is my role? Well, as an attorney or any type of estate planning attorney, what our job is to advise and implement your goals and objections. So, again, usually people come to me when they have emergencies and unfortunately we have to deal with those emergencies in a specific way. But if you're being a proactive planner, I need to know what you're trying to accomplish. And when you tell me what those goals and objectives are, I will be able to assist you and help you getting there. So you have to think of me as a GPS. Once you give me all the information, it's my job to guide you where you need to go. And that's really it. But you have to be open and honest about all the different things that are going on in your life, what your specific situations are. Everybody has different, situations in life. We have different, our families are different. A lot of times people have kids that they adopted, they have stepchildren, they have, children from different marriage, and the relationships need to be discussed. At least they need to be discussed with me because I need to understand the dynamics so that way I can protect you in the way that you want to be protected. So you got to be honest about all those different relationships and how they affect you. So it's my job to guide you where you want to go. That's my role. Now, this is something that I always tell everyone. You are worth more than you think. So I don't want to insult anyone when I say that. What I mean by that is you have probably more assets than you think. A lot of times when people think about assets, they think about a house. And then some people always, people come to me and they want to create a trust and they'll say, but I don't have a house. I don't have real property. That doesn't, your life and what you have accumulated still has value. And the other thing is, those loved ones that you have in your life may find something that you have of value to them. And to the extent that you want to leave it to them, don't count that out as, oh, that's not worth anything. It might not seem that way to you, but if you want to give something specific to someone, it would be a value to them. So for example, if you have a car that's like 10 years old, of course cars are depreciating values. But if you have a niece or a nephew who's going to be going to college locally and they might need a car and you told them, "Oh, I'll give you my car." To them, and it's a great running car, nothing's wrong with it. The fact that it's 10 years old is neither here nor there. If it's great for them, that's worth a lot. And you have that asset and you want to be able to give it to whomever you want to give it to, right? So that's just one example. You might have jewelry, you might have furniture, it might be old furniture, but you might have someone who knows how to stain it and fix it up and make it, come to life again. So don't count out anything that you have and say that it's not important. So I always tell people you are more than you're worth a lot more than you think. You set the value of your life. No one else should do that for you. But if you don't do it, someone else will do it for you. And the person who will do it for you is someone you don't even know. So if you do not have an estate plan and God forbid something happens, now whoever is trying to get your assets is going to have to go to court to get them. And you don't have a will, so that means you didn't put anyone in charge. So it's either a judge or a public administrator, someone who is appointed by the judge, who is going to now go through your things and figure out what's worth what, sell what they need to sell, do whatever they need to do, because now they have the authority to distribute whatever it is that you have. So you don't want someone else, especially someone you don't know, to be dictating what your valuables are worth. So the goal is to translate your worth into wealth and then turn your wealth and legacy into generational wealth. A lot of people continue to throw those terms around, generational wealth. We talk about that all the time, but that is not going to happen if you don't have a plan. And, we're going to talk more about generational wealth and what that really means. Even when you have, you know, a lot of money that you want to leave to someone, if you don't plan it right, that money can just be spent in the blink of an eye. And it's not going to create generational wealth if there's not a plan for generational wealth. So you got to keep that in mind. Also, keep in mind that this is about investing in yourself, and that's a priority. And the following things are considered investments in yourself: the stopping the impulse buying, eating healthy, self-care. People talk about health-care as if that's something you should do once a month. No, it's not. It's something you should do every day. Saving money, doing some self-reflection, discernment, especially when it comes to the people in your life. You can love someone very much, and that's wonderful, and you want to leave them something. But if they're not good with money, you're going to leave them the money, and then the money is going to be gone within a month. And that's if that's not what your intent is, then you need to be very careful about how you leave the person the money. You can leave them the money, but you can put safeguards in place in order to make sure that that person gains more maturity and you so that way they won't just spend the money outright within a month. So this is about investment in yourself and it's also about investment in your loved ones. So just keep that in mind. So, what are the top 5 reasons that you should begin estate planning now? Well, because you want to take control over your assets. That's number one. You should be the one who is in control of that. And you do that by giving specific instructions to everyone who is concerned how you want those to be distributed. Number two, you want to provide for your loved ones your way, right? These are your assets, so you should be the one to tell whomever this is how you want them to be distributed. Again, if you do not do that and you have assets at the time of your untimely passing, someone else who you don't even know is going to be the one that takes control over your assets, and we don't want that. The third reason is you want to avoid unnecessary tax consequences. A lot of times people don't even understand what those tax consequences are because again, we say to ourselves sometimes that, I don't have that much. People tell me that all the time, I don't have that much. It's not just about having like a home, a house. It's not just about having furniture, or jewelry or things about that. All those things should be included, but what about your bank accounts? People don't understand that if you don't have beneficiaries or what they call a POD, which is a payable upon death, that now the person who's going to get that money has to go to the court. So, again, you have to really think these things through and you want to make these plans now. Um, Number four is make a proper assessment of your estate and make necessary adjustments. For example, you want to check on your stocks, annuities, any savings that you have. Maybe you want to make some transfers in terms of you might not be getting the best return on your investment with how you're saving right now. If you have all of your liquid assets in, let's just say, a traditional savings account at a traditional bank, if the return rate, the interest rate on that is lower than if you would have it in a high yielding um, interest rate account. You should do some investigation to figure out what that would be. If you have an American Express card, they have a feature where they have a high yielding interest rate savings account. Or there's other products out there with different investment companies that might have a better product or a better return on your investment. So things like that you want to think about. Do you have any annuities? Do you have any stocks? Is that something you should be thinking about? A lot of times we just think about the basics. I have a regular checking account, someone will tell me, and I don't really have a savings. Well, maybe that's something we should start thinking about. Do you have a 401k? Do you have a pension? What do you have? Did you work for the government? And what's going on with any type of plans that you participated in? So those type of things, think about everything. And sometimes people will tell me I have these bonds that I bought, but they're not worth anything. And when was the last time you checked on them though? So we need to make sure that we're making the right assessment by investigating. We have to make phone calls. And a lot of times things are done online. So, we can do these things as quickly as possible a lot of times. And then the fifth reason why you want to begin estate planning now is to eliminate family feuds over assets. You'd be surprised how often people will fight over money. And I'm not even talking about big money. People will fight over $10,000, $5,000. And if that is not your intent, then you can avoid that. Family feuds destroys assets and diminishes generational wealth. I've heard a lot of different stories. Like I said, people come to me a lot of times when they have issues, but you want to avoid this. And that sometimes has to do with the relationships or the people in your life. And this is the part when I say you need to know who these people are. So, for example, you have three kids. All those three kids are not the same. And I know that for a fact. Even if you have twins, trust me, they're different. You have two twin girls, two twin boys, they are different. They are not the same. They might look the same, not the same. You have to be honest with yourself with how those children are. That's it. You have to be. Now, your intent may be, I want to leave all three of them, all four of them, all five of them, whatever your situation is, everything's equally. But the manner in which you do that is going to make the difference, right? Your children may be in different spaces in their lives when you are no longer here. So again, you need to sit down with someone so that way that person can understand those specific dynamics. So like I said, if you have three kids, let's just say one is horrible with um, saving money, and let's just say one is great with saving money. And God forbid, let's just say one it has a substance abuse issue, but you love all of them equally and you want to take care of them. You need to sit down with someone to figure out a plan that you can do that. Personality traits, gifts, in terms of personal gifts that people have, personal traits that are strong, some personal traits are weak. You have to take those into consideration when you are planning. Just saying that you're going to give all your kids equally and that's it, they have to get the money outright, might be a mistake. And you want to make sure that you do this the proper way. So you want to avoid feuds and you also want to make sure that they're taken care of properly. There are different type of things that you can do. And whether it's in your will or in a trust, there's different features that you can utilize in order to make sure that money's not spent outright or people get money at different stages or in their lives when they turn certain ages and stuff like that. So there's all these type of things that you can do, but you have to be honest about, the people in your life and how you want to provide for them and what issues you have to address in order to make sure that, they will utilize this money in the manner that's going to be best for everyone concerned. So those are the type of things. These are the five reasons that you need to know about when you talk about estate planning. So now let's talk about the five essential documents, right? Everybody may not know these essential documents, but these are the five essential documents. It's your last will and testament, healthcare proxy, living will, power of attorney, and trust. Now, if you don't have these documents, again, you should sit down with someone and talk about their meaning and how that applies to you and what you should do. We're going to go over briefly each of these documents just so you have a basic understanding of what they mean. Let me see it. Can I check the chat and see if there's any question? Oh, so we have someone from Queens, Brooklyn. Oh, Brooklyn in the house, Queens in the house. That's great. I love it. Um, so now, okay, so these are the documents. These are the five essential documents. And so let's just talk briefly about the last will and testament, right? So the last will and testament is a person's final declaration of how they want their assets to be distributed. And, there's elements to the last will and testament. This is what needs to be in that document. There's an introduction, there's an identification of the person whose last will this is and where they reside. All those things are important in terms of what law is going to control. Sometimes people have property in different states, but if their residency is in New York, then you could provide for those properties elsewhere in the will. So again, if you sit down with a professional, they will let you know what you need to do. Now, when you start to go into the will, first you talk about specific gift bequests. So, like I said, some people have specific gifts that they want to give to specific people. Like I said, sometimes jewelry, they'll say, "Oh, I want my granddaughter to have that." Or furniture, I want my daughter to have that. Or, something that someone may have admired that you have and they told you that and you love this person and you say, "You know what? I want that person to have it." And it's important to do that because, again, when especially when someone, if someone is sick and you know that they're going to pass, that's one thing. But that's not just how life happens. Sometimes things happen and a person passes away. There's been plenty of instances where people will come in the home and start taking things. And so again, you want to avoid that type of situation happening. So that's why you have specific gift bequests for things that you have. Maybe, and then you have personal property bequests, and then the real property bequests. If you have a house and you want to give it to a specific person, you can put it in there and that's how it is. And then you have what they call the residuary clause, and that's all the things you didn't talk about in the other clauses, and you say, I give the residuary or the rest of my estate to, you know, X, Y, and Z or whomever. So that's what's the residuary clause. Sometimes in your will, you will create a trust, especially if you have minor children. So you can create a trust in your will, or you can create a trust outright, right? So you can put it in your will, but again, the will would have to be probated. And, we'll talk about the ramifications of that. But you can put a minor's trust in there. But if you created a will and you put in a minor's trust, and let's just say your will is 20 years old and now there's no more minor, this is why you have to always look at your estate plan and update, right? Because you don't need the minor's trust anymore, right? And there may be other things that you don't need anymore. Also, you may have sold certain things. So you might want to rearrange things or maybe give something to someone else, or if something was updated, you want to make sure that it goes to the right person. So this is why you have to look at your estate documents, especially if they're like 10, 15, 20 years old, or if there have been life-changing events in your life. You have a grandchild, or you have a child, you have another child, you adopted a child, you got divorced, and now you got remarried. Those type of things are very important. So that will change. And if you have an old will that's outdated, that's going to cause problems. So you got to keep those things in mind. Life changes all the time, and you have to make sure that things are up to date. Now, you also want to name the fiduciaries. Those are the people that you put in charge. So if you have a will, the person that you put in charge is called the executor. That's the person, and people don't understand this a lot of times. People think that that person inherits the money. No, that person is in charge of making sure that the assets are distributed in accordance with um, now they call them the decedent. So whoever's will that is, and whoever they put in charge, that person is required to make sure that the specific your specific instructions are followed. Now, in New York State, by statute, that person does get what they call statutory commissions. So even if the person did not leave the executor money, they will get commissions based on whatever the value of the estate is. So let's just say the estate is worth $1 million. Once everything is taken in and they file a document to show what the estate is worth, the person who is the executor or in charge of making sure that everything is distributed, they will get a commission based on that value. It's a certain percentage by state statute. Okay. Um, and then the will talk about what the powers of that person or persons are. It'll say what they can do. It'll say if there's property, real property in the will, the powers will say the executor can do whatever they want, pretty much. I mean, we'll put language in there to be very specific, but they can mortgage off, take out a mortgage, or they can, if let's just say the property is in foreclosure. The will could give them powers to do whatever it is that they need to do in order to try to salvage the house and make sure that the beneficiaries get paid. So, it's very important what the powers of the fiduciary is in the will. Then there may be other provisions in the will again, depending upon what your specific situation is. Everybody has their own situation, they have their own dynamics, they have their own family. And so you have to sit down with someone so that way they understand all of those issues so that way they can make the proper assessment and advise you accordingly. And then there's a signature and attestation, self-authenticating a witness affidavit. So here's the thing about a will or a trust. The person has to be competent in order to execute the document. So again, a lot of times people come to me when someone's ill. If the person is incapacitated, I'm not going to be able to draw up a will for them. And people come to me like this all the time. If someone has already been diagnosed with dementia, or if they have some type of diminished capacity, that's going to be a problem. This is why you want to do these things now and not wait, because you just never know. Sometimes hospitals, I've seen cases where the family didn't even know that they, diagnosed a loved one with dementia or something, or Alzheimer's or something like that. Now, then someone comes to me and, oh, we need to do a power of attorney. Well, I can't do that now. You can't do that because if the person has some type of diminished capacity, they have to understand and appreciate what we're going to execute. So again, that's why you really shouldn't wait for these things. The other thing you need to do is understand, to the extent that you can, understand your family medical history, right? So if cancer runs in your family, again, this shouldn't be the only reason why you be proactive about planning, but if you have this information where there's something that, runs in your family that may cause problems, that's all the more reason why you need to be proactive and plan. Okay? So just keep that in mind. So these are the elements of the last will and testament. So now another document is the healthcare proxy and the living will. So the healthcare proxy allows you to choose who you want to make medical decisions on your behalf. It's a straightforward document. It lists who you want to be the one to make medical decisions on your behalf when you cannot do it for yourself. So now sometimes people come to me and they say, I want my mom and my sister. You can't do that. For a healthcare proxy, it has to be one person, and this is by statute in New York. You cannot have joint actors as healthcare proxies. You can have one primary person and then you can have an alternate, but they can't be two people who act at the same time. Okay? So keep that in mind. So when you're choosing a healthcare proxy, you really have to be careful and choose someone who is going to execute your wishes. Some people have very strong wishes about medicine and treatment. And if they're in a certain state, they may not want certain treatment. You have to choose someone who is able to abide by your wishes. If it's someone who is too emotional and will not be able to do as you would like them to, then you really need to rethink it. So it's a very important decision and you have to make it based on, again, what you know, what you understand about the person, and, choose the person who you think is the best person for this type of decision. So choose a healthcare proxy you trust to carry out your wishes with respect to medical treatment. Think intently about the person you choose. It should be someone who can actually carry out those instructions, someone who's level-headed, not overcome by emotion, such that they will be unable to make the correct decision for you. And they should share similar religious beliefs with respect to life and death. So those are the type of issues you need to think about. So a living will is used in conjunction with a healthcare proxy. It actually tells the healthcare proxy what type of medical treatment you will accept. So that's why they go hand in hand. The healthcare proxy is specifically about the person who you put in charge. The living will are the instructions for that person, right? So if you do not have a living will, that means your healthcare proxy will make whatever health decisions on your behalf without your input or direction. Now, some people are okay with that. But some people, most people have the living will in place so that way it takes the pressure off of the person to have to make the decision themselves. They just know what the living will says, and they will go by that. Okay? Power of attorney. So now, healthcare proxy is about medical decisions, power of attorney is about financial decisions. A power of attorney allows you to choose who will make financial decisions on your behalf. This power can begin immediately or when you become unable to make those decisions for yourself. Okay? So once you fill out that power of attorney, you can have them do it immediately, or you can just direct them when you want them to start acting on your behalf. Now, unlike the healthcare proxy, for the power of attorney, you actually can have two individuals to act jointly, or you can have a primary and an alternate. So just remember, healthcare proxy can't have two at the same time. Power of attorney, you can. Okay? So now just a few things I want to say about the power of attorney. So, power of attorney terminates upon death. So, once a person, people think that a power of attorney is, I mean, it is an estate planning tool, but it's not going to help you beyond the person passing. It's something that you're doing now for the person, and you should start to take care of those things at their direction, like make whatever changes on the bank accounts or whatever it is that they want you to do. It's great to start doing that, but if you don't have a will or a trust or something in place, once that power of attorney terminates upon death, that person is going to have to go to court to continue acting on that person's behalf. That's one of the biggest mistakes that people make, thinking that the power of attorney survives the person's death. It does not. As soon as that person is deceased, that power of attorney terminates. So just be mindful of that. The other thing that you need to be mindful about a power of attorney is the banks. So when you execute a valid power of attorney, a lot of times the banks will give you issues. You need to call the attorney who executed your power of attorney because the banks sometimes, it depends on the bank, but sometimes the banks will tell you, oh, you need to do this and you need to do that, or they'll have an internal process that might take a month. And if you don't have a month to wait that long, you need to be able to go back to your attorney so they can speak with the bank. A lot of times banks hold up these power of attorneys and tell people that they need to go back and do something else when that's not the case. So don't be intimidated. You need to go back to your professional and look over that power of attorney and make sure that it was correct. And if necessary, you might have to engage that attorney to contact the bank. This has been a serious problem with power of attorneys. And again, we might have a seminar where we talk specifically about power of attorneys because there's a lot of issues that have come up with that. So if there's any pushback, you have to be able to go to an attorney and try to resolve the issue because you may not have that much time, depending upon where the person is who gave you that power. Um, are there any? We are going to take some questions at the end, but I don't mind taking some questions now before we talk about a trust. What if you are the last one left? What does that mean? What do you mean the last one left? I'm not sure what that means. But what we can do is I'll answer that question when we get to the end. Okay. So now, what is a trust? So a trust is a legal vehicle that allows for the transfer of assets to a trustee. A trustee holds legal title to property and manages the property for the benefit of one or more beneficiaries. Trusts can be revocable or irrevocable, and that's very important. We're going to have more of these sessions where we talk about specifically trusts. We're going to break down certain topics because this is a very important topic, and a lot of times people don't understand why you may need one trust over another. But for now, just understand that trusts can be revocable or irrevocable. Revocable trusts are often referred to as will substitutes. So sometimes people will have a trust instead of a will. I'm going to tell you my opinion on whether or not you should have a trust or will, or if you should have both. But for now, just understand that revocable trusts are referred to as will substitutes. Now, while revocable trusts are treated similarly to wills, there are differences between the two, and there are advantages and disadvantages for both. And we'll talk a little bit about that as well. But just understand that that is a legal vehicle. So, what types of trusts are we talking about? So they're called either you can have an inter vivos uh, trust or a testamentary trust. So an inter-vivos trust is one where you're living and you have a trust that's in effect as you are alive, and then one that is, takes effect upon your death. There are revocable trusts and there are irrevocable trusts. I will talk about the difference between the two. And then you have something that's called decanting, which we'll talk about a little later as well. So now the parties to the trust. Number one, they'll either call it the grantor, that's the person who is putting the property into the trust, or sometimes they're called the settlor. Again, it depends on what type of trust we're talking about, but they are essentially the creator of the trust. The second party would be the trustee or the fiduciary. That means that's the person who manages the trust. And then the third person would be the beneficiary. It could be a lifetime and the remainder men. So sometimes you have beneficiaries and then you also have, like for example, you might give the property to your children, and then you'll say if your children are no longer alive, then it will go to your grandchildren. They would be remainder men. So you just have to understand the terminology and what that means. But those are the three general parties to a trust. So now let's get specifically into what a revocable trust is. So a revocable trust, living trust, is a flexible trust that can be amended or changed or revoked by the grantor or settlor at any time during his or her lifetime. So I mean the name is certainly in the document, right? When you say revocable, it means exactly what revocable means. Mean you can revoke, means you can take it back, the same way you can do a will. So if you have a will, and it's all executed, everything is fine, you can either amend the will or you can um, take it back. You can destroy the will, create another one, or do something else like create a trust. Same thing is true with a revocable living trust. You can put property in there, whatever you need to do, but you can amend it if you want to, or you can decide that you no longer want it and you can, destroy it. So that's really what a revocable trust means. And what's the benefits of a revocable living trust? It eliminates expense and time involved in probate. So let's be very clear. If you have a will and that's the only thing you have and you have property or whatever in that will, you have to go to court in order for your assets to be distributed. That's not the case with a trust. The whole point of putting property in a trust, well, there's a few reasons, but one of the main reasons is so you don't have to go to court. A trust document is a private document as opposed to a will that has to be filed with the court and it will be a public record. So if you want to do this in a private fashion, then you would definitely want to have a trust. And the trust allows control of assets beyond the reach of a will, right? So once it's in the trust, but you have to make sure that you take the steps to make sure that the trust is valid. There's been times where people actually create trust, but then they don't fund it. If you do not fund it, that's going to be a problem. You have to make sure it's funded. So, for example, if you create a trust and you put real property in it, you actually have to make sure that there's a deed that is recorded where you're transferring the property from the individual into the trust. And you have to file it with the county clerk's office. So if you're creating a trust that you're just putting money in, you have to actually fund the trust. There's been many instances where people actually create the trust document and it's all signed and everything, but then no money goes anywhere. There's no account, a trust account that was created or anything like that. That may cause problems because there's an issue of whether or not the trust was actually created if it's not funded. So again, whoever you go to create these things, they have to do it properly. And a trust is private. So it allows for control of assets beyond the reach of a will. It avoids ancillary proceedings for properties located outside of the state. So when you create a trust, there's the last page has what property is being put in the trust. And, you can continue to add property or anything that you want to put in that trust as long as it's listed in the trust. So if it's in another state, you don't have to worry about filing some type of action in that state to get control of that property. And, sometimes people have to do that because they didn't plan properly. So if your goal is to have different properties in different states, you want to make sure that you plan accordingly so that way you don't have to hire an attorney in the 10 states that you have different properties in to get control over that property. You see so these are the type of things that you have to think about. You have to make sure that you plan properly to make sure that you don't have to spend unnecessary funds to get control of the property. Because again, what we're trying to do is make sure that you have control over your assets, but also that you're not spending unnecessary time and expense in order to gather all of your assets. So that's why you have to be, honest about what you have and make sure you include everything. So that way everything can be accounted for. Um, the revocable trust also provides asset management in case of incapacity. So, this happens all the time. So if you created a trust and God forbid, the grantor is has become incapacitated after the trust is created. Well, the trust will survive because there's a trustee, right? So if the person is incapacitated, the trustee now is going to be able to take control and do what needs to be done. You don't have to worry about, oh, this is an issue that we have to address. You already addressed it because there'll be language in the trust that accounts for um, incapacitation. So that's why you want to make sure that you're okay, as opposed to just having a power of attorney in place. Now, if the power of attorney is in place and the person is incapacitated, yes, you can act on their behalf. You can. But again, if the person passes and there's no trust or will in place, now you have a problem. So the power of attorney is a great tool, but it's not an end all be all. You still need to have a will or a trust in place in order to, make sure that you're able to act after the person cannot act on their own or they are deceased. The other thing you can do with a trust is you can disinherit potential heirs. So the trust can be very specific, saying that you're giving the property to whomever. Again, it's a private document, and you're able to, do whatever you want to with your property. There is no gift, so there is no tax consequence. Again, we'll have another session when we talk more about that because a lot of people are confused about the gift tax and other tax consequences that they are unaware of, whether we're talking about a will or a trust. So we have to really talk about that more in depth. So what assets can be placed in a trust? So you could put real property in there. You can put bank accounts and brokerage accounts. You can even put cooperative apartments and personal property in your trust. But listen, you do have to be careful. So for example, if you have a house, and this happens all the time, you might have a mortgage on the house. You can still put the house in the trust, but if you have like a reverse mortgage or you have a HELOC, you guys know what a HELOC is? You have a line of credit or something like that. See, again, you have to be very honest about what is going on with the property, okay? Because that will affect whether or not we can place it in the trust and what the consequences are. So, again, we don't have time to go through all of that, but I just want to mention that because a lot of times, excuse me, a lot of times people do have issues with real property. And you got to be honest with what's going on with the property. Okay. um so just keep that in mind, but these are the type of things that you can put in to a trust. um Step up in cost basis. So here's the other thing about assets that are put in a trust. Assets in a revocable living trust are counted as the overall gross taxable estate of the grantor or settlor. Therefore, beneficiaries will receive a full step up in cost basis. Keep in mind that there is um, no gift, so there is no tax consequence. So let's just visualize this for a second. So let's just say your parents had a house that they've owned for 30 years. They bought the house at $50,000. They had the house for 30 years. Let's just say the house now is worth 2 million. Unfortunately, your parents pass away and you now, the only child, inherited the house. You are going to inherit the house not at what they purchased it for. What you are going to inherit it at the $2 million price that it is worth. Okay? So that's a good thing because that's what you'll get. There's not going to be any gift tax because it's in a trust. It's not a gift. Um, and then, you put it in the trust so you don't have to worry about the capital gains tax that you would have to pay on that step up in basis. We're talking about $1.9 million increase. That's a lot. So now let's just look at this objectively. If you didn't have a trust, so the same circumstances, your parents bought the house at $50,000 and then, they passed away, the house was worth $2 million. You inherit that house. but there's no will. You're an only child, so there's not going to be a dispute, but you have to go to court to prove who you are. Let's just be very clear about that. There's no will, there's no trust, there's no nothing. Parents bought the house at 50,000. It's now worth 2 million at their death. You inherit it. You will get the step up in cost basis, but now you're going to have to pay capital gains tax. And you got to go to court to prove that you're the only child because there was no will and there was no trust. That's going to take at least a year, depending upon what county you're in. It takes at least 7 months. And so these are the type of issues that you have to think about. But if they had put it in a trust, then you could avoid those capital gains tax. And you don't have to worry about the gift tax. So that would be a win-win for you. So again, you have to sit down and talk to someone about all the different issues and things that are going on with the property and make sure that you get what you need and have the right mechanism or vehicle for for the person who's going to inherit that property. Now, you should have it. So if you have a trust, and again, right now we're just talking about revocable trust. I have not been talking about irrevocable trusts. This is just revocable trusts, which is a whole nother uh, ball of wax, as they say. And we'll talk about that more in depth. I mean, we can do a seminar just on irrevocable trust because there's so many different types. But for now, let's talk about the trustee succession, right? So you have a grantor and settlor, and they should have a trustee succession plan. So, again, you have that one person that you trust that you want to have as your trustee. That's great. So if the grantor or settlor becomes incapacitated or deceased, who is the nominated trustee? That person would take over. But just keep in mind that you might have sub trusts within the trust. Sometimes people do that. You'll have a trust, you'll put property in there, but then you'll have a trustee, and let's just say you have minor kids. You might create a sub trust for the minor kids and have maybe the guardian be the trustee of that sub trust. I'm not suggesting you do that, but I'm saying if the trustee that you chose is, let's just say, your sister, but then you have other, minor kids in there and they have parents, you might want the parent to be the trustee of the sub trust. Make sure you mention that. So you got to be very specific if you are going to make the sub trust or have other things in the trust. But if you want that one person that you trust to be in charge, that's fine. But you should also have an alternate trustee because again, things happen. I tell people to do the same thing in a will. If you have an executor, you should have another person to take over if that person cannot for whatever reason. They don't want to. They moved out of state and they can't come and do something like that, or they're deceased. You want to have a alternate plan. You want to have a succession plan. Now, if there are co-trustees, make sure that the roles of each trustee are clearly defined and provide for instructions in the event that one of the trustees can no longer serve. So again, these are things that you have to think about and make sure that you have the right thing in place. Be honest with the person who's advising you so they can give you the right advice. Okay? Give them all the information that you need. I always tell people you don't have to tell everybody your business, but you do have to tell your attorney what um give them all the information so that way they can do the right thing on your behalf and guide you, right? That's what they're there for, to advise and guide you into the direction that you want to go based on what your goals and objectives are. So, here's a question and I want you to put an answer in the chat. Should I have a will or a trust? What do you think? Yes, no, maybe so. Let's see what the answers are. Sandra said yes, both. Ann says both. Who else? Don't be shy. Aaron says both. Michael says trust. Lori says both. Anybody else? Oh, I see another one. Depends on the assets I want to pass on. Anna says that. Okay, who else? And I'll give you the answer once everyone gives me an answer. Most of you said both. One of you said a trust, and the other says the Anna says depends on the assets I want to pass on. Oh, I see a new response. Let's see what they say. Trust. Latoya says trust. Okay, so you want me to give you the answer? Yes. Okay. So the answer is you should have both. And the reason why is, so if you have a trust that has, you put your property in the trust and, you go about your business, you're like, okay, great, I created the trust, I'm fine and stuff like that. Again, remember, life goes on and, things happen. You might acquire more property that you're not even thinking about putting in the trust that you probably should put in the trust. You should have, so in that case you should have what they call a pour over will. So write that down. It's a pour over will. And a pour over will is really a safeguard for the trust. It basically says there is a trust in place. The will acknowledge the trust and when it was created, and it will say essentially to the extent that um, we did not put certain property in the trust, we are telling you that it should go in the trust. So it's really a safeguard, and it's to get that property that you failed to put in the trust and say that it's going to go in the trust. Now, that's great because um, that means you don't have to go to court and all that kind of stuff. I mean, if there's any type of dispute, you would take that will and go to court and have it determined that, the trust controls and stuff like that, if necessary. But hopefully that won't be the case. But you put that will in place so that way it's like an overflow for any property you may have acquired that you neglected to put in the will. I mean, in the trust. So you should have both. So that way you will account for everything. Again, you should be updating your documents anyway, but sometimes people don't get to it. I recommend that every time you have a life event, you need to look at that. And then if you don't have a life event, but years have passed by, you need to think about, well, what have I accumulated? What assets have I added on? So that way you can update as necessary. Okay? So you guys did great. So yeah, so you should have both. And you guys are ahead of the game. This is good. So now again, we will have some more sessions where we talk about this more in depth. We really can't talk about this too much, but the question is, does a trust provide tax savings and asset protection? That's why there's a difference between revocable trusts and irrevocable trusts. So now the revocable trusts do not provide income tax or estate tax savings. They do not provide significant asset protection for the grantor and seller. And I'll explain that a little bit when we start talking about irrevocable trusts. Okay. Mostly, I will say this. Most of the time, people come to me about a revocable trust because they have um, a house, they have real property, and they feel like that's the only asset they have, and they want to try to avoid that capital gains tax. So you can put it in a revocable trust, and then you that'll help you with those taxes. Because if your property, like I said, has increased in value significantly, that's a lot of capital gains taxes. When we do the calculation in the office, when people um, come to the office about that specific property. So I let them know this is how much money you have to pay in taxes if you don't have a trust to put this property in. So that's usually One of the biggest reasons why people come for a revocable trust. So now what about a joint trust? Um, I don't do too many joint trusts. It depends on what your situation is. If you're a married couple and you have joint, all of your property is joint property, you have children, it's all children by the two of you and no outside children, then it might be appropriate to do a joint trust. So it's usually primarily for spouses with the same children, right? And today we have all types of blended families, which is fine. But if that's the case, I would not recommend to do a joint trust. Um, but if you did, it would be people with the same spouses with the same children. The trust is funded with joint property. So if all the property you have is jointly owned, that makes sense. These type of trusts can become irrevocable at the death of the first spouse and may become irrevocable when both spouses die. Again, it depends on the language, but a lot of times that's what you do, especially if they have all of the same assets together, then this shouldn't be really an issue to do a joint trust. But generally speaking, because people have different situations and blended families and all types of different families today, I don't usually recommend a joint trust. And then the power of appointment is typically retained by both spouses. A power of appointment means that, there'll be some type of powers that the other spouse would have once one is deceased, and then, might add on to their powers or something like that. But again, you have to have that specific language in there when you're talking to your attorney, and they'll explain all of that and what it means. Again, these are specific types of trust for specific types of situations. So let's talk a little bit about irrevocable trusts. An irrevocable trust can also be inter vivos or testamentary. It can be when you're alive or when you're in your will, right? All inter vivos trusts are presumed to be irrevocable unless the trust clearly states otherwise. So now, when someone is drafting your trust, whether it's revocable or irrevocable, in the title it should say revocable or irrevocable. If it doesn't say it in the title, then that either first page will tell you whether or not it's irrevocable or revocable. If someone fails to put that language in there and they don't say whether it's revocable or irrevocable, it will be presumed to be irrevocable. So usually they'll state it right up front in the title. But I've seen trust where it just says living trust. It doesn't say revocable or irrevocable. But then when you start to read the body of the trust, it will tell you if it's revocable or irrevocable. So just keep that in mind. Irrevocable trusts are used for many different purposes. Okay, so just keep that in mind. There are tons of types of irrevocable trusts. But the main ones that people usually come to me for are for asset protection, tax planning, and Medicaid planning. So, if you and your spouse have high salaries and you have a lot of, you have a lot of money saved up and stuff like that, and you're going to hit that millionaire tax, in order to protect those assets, now you have to really think about what type of trust you're going to get. Because if your combined income is going to reach a certain level, then that's when people use irrevocable trusts to plan for asset protection and tax planning. And then the main one that a lot of people come to me for is a Medicaid planning trust. A Medicaid planning trust has to be irrevocable. It has to be. It cannot be revocable. Okay? That's very important. And people need to understand what revocable means. The primary purpose of an irrevocable trust is to remove the assets from the grantor's control. So I just want to be very clear about that. An irrevocable trust means that the grantor it loses control over the asset. Okay? That's important to know because, see, a lot of people don't like that. But that is really what an irrevocable trust is all about. It's about losing control. And once I tell people that, sometimes they're like, oh, no, I can't do that. But you have to go by what the need is and what you're trying to accomplish. If you're thinking ahead, which you should be, and you're thinking about for Medicaid planning, because there's a 5-year look back period for Medicaid. Again, if you come and sit down with an attorney and talk about this more, you'll understand exactly what the ramifications are and what needs to be done. But you have to, if you want to qualify for Medicaid and your income is over the threshold of what is allowed under Medicaid, then you have to, you know, protect your assets. Because if you get on Medicaid and you have these assets, Medicaid is not going to come and take your house because they know you live there. But when, God forbid, when something happens to you, there will be a Medicaid lien on your house. So this is why people do proactive planning. Having a Medicaid planning trust is a proactive measure. You can't, once you get sick and now you're going to need Medicaid, you're behind the eight ball at that point. Because even if someone did the irrevocable trust right now and you need Medicaid next month, you it's not going to work because now Medicaid is going to look back 5 years to see if you own the property. And, that look back period is very important. So this is why this is a proactive type of planning. It's not a trust that you do when you're in trouble somehow. And a lot of people don't understand that. But they don't want to do it because when I say you're going to lose control over the house. Now, what that means is and again, we'll have a session where we talk specifically about all the different aspects of an irrevocable trust. But that means that once it goes into an irrevocable trust, that house is no longer part of the grantor's overall estate. That's how you're going to be able to qualify for Medicaid because that house now is not a part of your estate. Your estate, if that house is worth $1 million, that $1 million is no longer a part of your estate. It's going to be in the trust and it's going to be in the control of a trustee. And the other thing is you cannot get any part of the principal of that asset. So if if the trustee sells the house, you can't benefit from the principal. So if the trustee sells the house for $1 million, you as the grantor cannot get that principal. You can't get that $1 million. Because if you do, it's part of your assets, right? And then you'll be in trouble with Medicaid. So again, you have to really understand what this means when we talk about irrevocable trusts and Medicaid planning, so that way you understand the full scope of what it means and why you need to do it and what are the consequences. Now, what you can do is you can benefit from the income. So, like, for example, if we put the house in an irrevocable trust, and let's just say you're renting out the bottom, let's just say it's a two-family house. You're in the top and you're renting out the bottom. Now, conceivably, you as the grantor can benefit from the income of the house, not the principal. Again, if you sell the house, you can't get that money. But if there's income being generated from that house, you can potentially get the income. But again, you got to be careful because if you get income, that's going to contribute. You can't go over the threshold of what Medicaid requires. So again, you have to be very clear about what you're doing to make sure you don't run afoul of any rules or regulations that you're trying to comply with. If you're trying to qualify for some type of governmental benefit, you have to be very careful and understand what the rules are. The other thing is, listen, this is the house that you're living in. The irrevocable trust will say that this is your place of residence. A lot of times people are concerned because they feel like if I give control of this house over to somebody else, they'll put me out. Nope, they're not going to do that. That's going to be your home. God forbid the trustee has to sell the property. The trustee would have to find you a place to live. That language should be in the trust. So if your concern is that, oh my God, they're going to kick me out because I gave total control over to the trustee. Again, this is why you have to choose your trustees wisely. But Medicaid knows that this is where you're living. And you're going to state in the trust that this is your residence. And you're also going to state that, the trustee can sell and do whatever they need to do, blah, 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 blah. But then they would also have to find you another place to live if they sold the house. So again, when you speak to your advisor, you have to get the full scope of what all of this means before you think that, this is going to be my demise. A lot of times people just don't have that trusting nature when you tell them that somebody's going to have to take control of something. So these are issues you have to deal with in order to make sure you're making the right decisions and doing what you need to do in order to protect yourself. So, a lot of these things are scary. That's why you have to really talk to the right people to make sure you're making the right decision. It's not an easy one, but you have to really understand. The other thing is before you even get to the Medicaid, before you apply, you need to speak to someone who can help you understand what type of insurance coverages you have. Usually the person who is trying to qualify for Medicaid is probably on Medicare, right? They might have some other insurance that's in place. You need someone who is able to help you navigate that to make sure that you're getting all of the benefit from the insurance coverages that you have. Sometimes people don't even know all that's available to them on the Medicare plan that they have. And a lot of times people don't tell you. Um, you have to find out. So you need to be advised properly in this whole context to make sure you're getting all the benefits that you are entitled to. So it's not really just a simple thing. You got to keep in mind that this is, something that you really have to get advisement on in order to make the right decision. But just keep in mind that the primary purpose of an irrevocable trust is to remove the assets from the grantor's control. Okay? So these are some of the types of irrevocable trust. Again, we don't have time to talk about all of this, but you have what they call a credit shelter trust, a Q-tip trust, which is a qualified terminal interest property trust. This is a very involved thing. Qualified personal residence trust. There's even a generational skipping trust, special needs trust. That's another type of trust that people do come to me with. If you have a special needs child, or there's different types of trusts that you would need to know about depending upon what your situation is. If you are philanthropic and you want to create a charitable trust, that's also something you can do. There's also life insurance trusts. Now, generally speaking, life insurance proceeds are outside of probate. And, when you have an insurance policy, you list the beneficiary that those proceeds would go directly to your beneficiary. But some people elect to put the life insurance proceeds in a trust. Again, it depends on who is the beneficiary, how old they are, what their situation is. You might want to provide for someone, but they're not best with spending. So you put it in a trust because you have a trustee who will give it to them in increments at certain times, things of that nature. So again, you have to think about the people you're trying to provide for and understand what their shortcomings are as well as what their strengths are and make the right decisions for that person. So just keep that in mind. Now, um, under the New York Estates Property Trust Law, it allows for an amendment or revocation of an irrevocable trust. And that's not easy. It's not a simple thing that can happen now. Just keep in mind that when it's irrevocable, it's 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 usually something that you can't do, but there is an allowance for it based on certain things. It requires that you have written consent of all the persons who are beneficially interested in the trust. So if you have a trust, an irrevocable trust, and it has five beneficiaries, all of those five beneficiaries have to consent to either an amendment or a revocation of that trust. And if one of those beneficiaries is a minor, now you have a problem. Or if one of the beneficiaries is incapacitated, see, that's going to cause problems. But you got to keep in mind if that's something that has to happen, it has to follow strictly by what the statute says. So that's why you have to make sure when you make this trust, this is something that you want to do. Think about your beneficiaries. Think about, what you're trying to accomplish. So this is just a little comparison between wills, revocable trusts, and irrevocable trusts. So what's the will? It's flexible. You can use it for estate tax planning, property distribution. It's the least expensive. But I tell people all the time, don't just have something because it's the least expensive. You want to make sure that you have things in place that's the right thing for you. So just keep that in mind. And remember, I said you should have both a trust and a will. The pour over will would be, again, it's not going to be such an involved will in terms of putting everything in there because you're putting everything in the trust. You're having the will as a safeguard to make sure that any property that you acquired after the trust was created, it will go into the trust. But if you only had a will and you didn't have a trust, now you have to go to court. You have to probate the will. That's going to take at least 7 months, at least. And it doesn't have any asset protection because once you file the will, if there's any creditors out there, they're going to look to see if anything is filed and they're going to, they have a certain amount of time in which to make a claim on the estate. So again, keep in mind that a will is a public document as opposed to a trust, which is private. Then you have the revocable trust. It's flexible. It survives incapacity, avoids the probate, some estate tax planning, fast asset distribution, retain control, difficult to contest, not impossible, but it is difficult. It is more expensive than a will. You don't have the asset protection because remember the assets, if it's a revocable trust, it's still part of the overall estate of the grantor, and it is higher administration costs. And then you have the irrevocable trust. It also survives incapacity, avoids probate, not going to court, private document, estate planning, estate tax planning. It can protect assets, harder to contest, fast asset distribution. The disadvantages, inflexible. So you generally cannot amend unless you follow the strict guidelines of the statute. And then it's loss of control. That's, generally speaking, Medicaid planning, but there are other reasons why you have an irrevocable trust. So I try to make this as simple as possible. But again, when you come and speak to someone about your specific situation, then you can get into more specifics. These are just general things about these types of estate planning tools. And that's it. Let me stop sharing. I know that was a lot of information. That's a lot of information. And it's just general information, right? But it's still a lot. That's why estate planning is really something that you have to sit down and speak to someone about so that way you can get the right guidance. Um, I see we have a question. Is it Liza? What are the costs for these services? So again, the lawyers tend to, speak in legalese and all that type of stuff, and I don't like to, um, do that. But the truth of the matter is that before you can give someone a cost of what it's, a cost of these type of documents, you have to understand what their overall estate is worth. So what usually happens is when you come in for a consultation, the attorney will probably either give you a survey or will have to ask questions so that way you can give them all of the assets and list them so that way we can come up with a value of the estate. Because again, if your estate is in the millions, right? Then it has to be structured in a way, especially if you're going to hit a certain tax bracket, right? So then that's going to be a specific mechanism that's put in place. Or if your estate is a house that you have and we tally up everything in your personal property and it's 500,000, then there'll be a different recommendation. So it really depends on what the size of the estate is before you can give someone a price, right? So you have to be realistic about that. Now, I tend to give out a survey. It's about like 20 pages. A lot of people don't like that, but when I work with senior citizens, that's something that is a little difficult for them to fill out. So I kind of work with them and talk to them directly and get the information myself instead of having them fill out the form. But for most people, you would fill out this survey, which would give me all of the information that I need. And once you start to fill out the survey, it kind of gets you in the mindset of, oh, I had this, oh, I have that. So it makes you put down things that you may not have thought of if you were just going off the top of your head. So that's the whole purpose of having the survey, so that way it could jog your memory about all the things that you have in your life that are worth something and you want to put them down on that form. So the answer to your question is it depends. Anna has her hand up. What's your question, Anna?
Thank you so much. This is so much to take in.
I
So
know.
I appreciate you breaking it down as simply as possible. I have a lot of questions that I'll save for our one-on-one.
Sure.
But um, is there any scenario that you can think of where neither a trust nor a will would really be applicable? And the reason why I asked that is because my mom is an older adult and she doesn't have a lot of assets. She has a 401k and bank account. And I went to see an attorney consultation
Hmm.
and he advised against setting up a trust because she didn't have any like real assets.
Hmm.
So is there any situations similar to that where a will or a trust wouldn't be advisable?
Well, I mean, I guess it is in theory it is possible, and I'm gonna tell you why. Before I'd ever tell someone they don't need a will or a trust, I would have to really speak with that person and understand what the assets are. So in your scenario, let's just say that you said your mom has, so let's just say she has 10
Just,
bank accounts
yeah,
and you're listed as the beneficiary on all the bank accounts, and that's all she has.
yeah.
Then y- y- then you wouldn't need to go to court for that, but she'd have to make sure either if you're a joint account holder,
Mm-hmm.
not just a name on the account, and there's a difference. Sometimes people just have their name, their child's name on the account. That's not the same as
Mm-hmm.
a joint account holder. So
Okay.
either you're a joint account holder or your name is listed as the beneficiary, or depending upon the bank, they call it a payable on death. If that's all she has, and I say that, a little skeptically, because again, I always believe that people have more than what they think they have. But let's just say,
Mhm.
for argument's sake, that is all she has. If your name is on there as beneficiary, as payable on death, then all you would need is the death certificate, and you would be able to go to the bank and be able to get all the money, and then you're done.
I see.
So yeah, I mean, so conceivably there may be situations where you don't need it. I find that when, especially when there's an only child, a lot of times, the parents already has the child's name on everything, and they took care of everything, and but we have to flesh it out and make sure, because if there's a retirement, if there's annuities, there's 401ks, you need to make sure that you're listed there as a beneficiary, and
Sure.
there's no other scenarios that would cause problems. And what I mean by that is, you know, it depends on your situation and who else is involved and
Hmm.
who could probably contest something,
Hmm.
right?
Hmm.
Um, so again, before I could say definitively that you would never need a will or a trust, which am very cautious about saying something like that, I would really need to understand what your situation is.
I understand.
Okay?
And and my last question is, can the trustee also be a beneficiary of the trust?
Sometimes they are, yes.
Yeah, okay.
Of
Thank you.
course, my pleasure. So again, like, so in your situation, what if the trustee is also the child of the grantor and the only child? So they would also be the beneficiary too, right? And then sometimes they're not the only child, but they're the person in charge, and sometimes they can be the beneficiary. But most of the time, people will put somebody else in charge, and then the beneficiaries would be different people. But there's pros and cons to that. And again, when you speak to the attorney, they'll explain to you why you should or should not have it that way. Any other questions? I know this was a lot. And again, we have sessions where we just talk about trusts. There's even sessions where we need to talk specifically about power of attorneys, because there's a lot of confusion around what power of attorneys can and cannot do. Talking about the will and more in depth about what that means in terms of going to court. It's a whole formal process, that you have to put people on notice. So, these are the things that you need to know to make sure that you're putting the right things in place. Let me see. Did I miss anything in the chat? Let's see. I don't think so. Wait, there was a question earlier and I said I was going to answer it later. What was that? Is the trustee the relative you put? Oh, wait, there are some questions I don't think I answered. Hold on. So Lori, are you still there? You asked the question, what if you are the last one left? What do you mean by that?
Hi. You answered it more than once. Like you're the only child left. Can the grantee and the power can it be one and the same person? The person who has the power of attorney and is also the person who's inheriting everything. You answered it twice.
Okay, but wait, I just want to clarify something. So when you said the last one left, okay, there's a difference between being an only child and you being the last child left.
Well, I am the last child left. I had two brothers. They both passed away.
Okay, but then, okay, so is this a situation where you're talking about a will or you're talking about a trust?
A trust.
Okay, so the trust should, I'm not sure what the trust said, but let's just say, um, did the trust list all of you as beneficiaries of
At
the
one
trust?
time or another, it did, and now it's
Okay.
just one left.
Okay, but did your siblings have children?
Yes.
Okay, so I don't, so again, sometimes the way people structure things, so I can't, when I said I said an only child, that's totally different because if it's an only child, that means there's nobody else who can make any
Yeah.
claims to that, right? But if you
Mm,
have siblings and some of your siblings are deceased, but they had children, and
mm-hmm.
depending upon when they were deceased and depending upon what the language is in the trust,
Mm-hmm.
it's possible that, sometimes people say that, if one beneficiary passes, they'll say their share will go to their next of kin.
Mm-hmm.
Or they'll say that it should be redistributed amongst the siblings. So I don't know
Mm-hmm.
what the trust says. You see what I'm saying?
Right. I think they're developing the trust to basically say everything comes to the one child.
Okay, so then that's
Yeah.
okay.
Yeah.
That's different. But just be careful. There's a difference between being the last child left and the
Uh,
person being an only child. So I just wanted to make sure
right.
that you didn't misunderstand what I said.
Yeah. Technically, my mother says, well, they have their mother left still, so they're okay.
Well, but she might say that, but the trust has to back that up. You understand what I'm saying?
Right. That well,
Um,
she's doing it. That's what I'm saying.
okay,
She's
okay.
that's how she's setting it up. I figured what I'll do is eventually sell the house and just give them share, give them something from the house.
Mm-hmm.
Just to make it less complicated.
Right. No, I
Those
totally
are
get
my
it.
thoughts. Huh?
I totally get it. Yeah.
Yeah. So I don't know. We'll see. This is a lot.
I know it is a lot. Um, and that's why we said at the end we would give people the opportunity to schedule one-on-one consultations to discuss their specific situation. Because again, this is just general information, and we're gonna put it in the chat where you can sign up for um, those sessions.
Okay.
Okay.
All right.
Um, I see that there's still some other. Did you have any other questions, Lori, before I?
No, that's it.
Okay. Thank you.
Thank you.
The only what someone said, oh, that's the only child things are being okay. Is the trustee the relative you put over property as example, or attorney's office? Is the trustee the relative? I'm not sure I understand the question. Sandra, are you still there?
Hi, yes. I think I wrote the question before you answered it. You answered it
Okay.
after I wrote it. So from
Okay.
my understanding, right, the relative or whoever the person is would be the trustee.
Yeah, usually people will put a relative as trustee. You don't have to put a relative as trustee. Um, you can put just someone you trust to do the right thing. And a lot of times people do that, especially they take it if you have more than one child, sometimes people feel that it will be better to put, if you have a sister or brother that you really trust and love your kids and you know that they'll do the right thing, so that way the children don't feel like, oh, mom trusted so and so over me, so you don't have those type of situations. But again, I always say you need to make that decision based on what is the best person that you should put, who is the best person you should put in place to make those decisions. So that the trustees could be whomever you feel will do the right thing or carry out your wishes to the best of their ability. So it could be a relative, could be someone else. Did you have any other questions? And then Anna said, can the trustee be the beneficiary? Yes, it can. So if I chose my husband as executor and he is a beneficiary, he will still get statutory commission. Yep. Whoever is the executor will get statutory commissions. So the accountant, when they, I mean, if your husband's getting everything anyway, let's just say it doesn't matter really, but it will be in the accounting. Um, but it wouldn't matter. But if someone else is getting something besides your husband and the will has to be probated, then yeah, when they do the accounting, it will list what the commissions are and it will say who it goes to, and that is whoever the executor is. Um, Someone asked if there's an option to make a consultation. Yes, I believe we will be putting something in the chat. Yes. And then let me see if I missed any questions. Are assets evaluated jointly? Can a healthcare proxy be filed for one parent and not another? Are assets evaluated jointly? Can you explain what you mean by that? Um, Generally, if you are married, Michael, are you still there? So, okay, Michael, are you still there?
He's having mic troubles, so he's
Oh,
been
okay.
typing in the chat.
Okay. Let me while he's doing that, let me just answer Ann's question. So Ann, where's the commission paid from? So okay, so when you let's just say if you have a will and it's filed and there are certain things that you have to do, you have to list all the assets. If their bank accounts are there, they do whatever the value of the estate is. And out of whatever those state funds are, that's where the commissions come from. The commission comes from the estate. So if the estate is valued at $1 million, um, that the commissions will be paid from the estate. So even if, a lot of times it's just people say there's just a house. There's never just really a house. There'll be a bank account or something or some other assets or something like that. When they calculate everything, you have to include everything and, the commissions will be paid from that. For the 5-year look back, yeah, that's a lot. What about the 5-year look back for the Medicaid compliant trust? Oh, Anne is asking, okay, if the value is a brick and mortar. Yeah, so if you have the house, and you're saying if that's all you have is the house, um, like I said, the commissions do come from the estate and everything that is in the estate. Generally speaking, let's just say it was just a house. There probably are other things. You have to list everything that is in the estate. Um, and if you're the executor and again, we don't know what the situation would be with the brick and mortar, whether or not it has to be sold or, whatever has to happen. But if there are any assets other than the house, you would get those commissions, or you would tell, whoever the person is that is inheriting the house, you would have to speak to them about how this is going to work, or, so you are entitled to those commissions. You don't necessarily have to take them, but you are entitled to them statutorily. So, as the executor, your job is to make sure that the assets are distributed to whoever they go to. So, even if you sold a house, right? If all there is a house, the house would be sold and you would get your commissions from whatever the sale of the house is, right? If that's the only thing that's there, but you are entitled to get that those commissions. Now, if the person doesn't want the house to be sold, again, you're the executor and you have the power to do whatever, but that's something that you would really work out with them, especially if it's a relative, a child of the decedent or something like that. These are usually personal things, but I'm just telling you that you are entitled to get the commissions. A lot of times people forego that, especially if there's nothing else really in there, but in the estate, except they just say they want to give it to the beneficiary and leave it like that. You don't have to. I'm just letting you know you are entitled, pursuant to statute, to get those commissions.
Oh, thank you, Rhonda. We'll talk more when we talk.
Mhm. Um, these are good questions, though. Um, Michael, I'm saying yes for the Medicaid compliant trust or home health aid from
Um,
a. Oh, I'm sorry. If you guys let me, I'll keep answering questions, but that's something, yeah, I would, for the Medicaid compliant trust, because there are so many different things, that's why it would be good if you um, signed up for a one-on-one consultation, so that way we could understand your specific situation. It's a very involved process. Okay, good, Michael. That would be great. Any other questions? Oh, well, thank you for joining us. This was wonderful. I thank you for all the wonderful questions. They were great questions.
Awesome. Awesome. Thank you so much, Rhonda. Let's give Rhonda a round of applause for this great presentation. If you guys learned something, found something valuable, please just put some hearts, show some love in the chat. Erin has dropped our information on how you can sign up for a one-on-one consultation with the Du Bois Bunch Center's legal arm. We have attorneys here with us to provide you with the necessary consultation for you to make the right decision moving forward. So please stay in tune, follow us on social media, subscribe to our website so you can see a series of estate planning topics that Rhonda discussed. And thank you all, and we look forward to seeing you all at our future programming. Take care, everyone.
Thank you.